I'll call this meeting to order. If we could have roll call, please.
Commissioner Hoffman.
Present.
Commissioner Asper.
Present.
Commissioner Heinzerling.
Present.
Commissioner Lamore.
Present.
Commissioner Wenzel.
Present.
Commissioner Swartout.
Present.
Commissioner Moore.
Present.
Commissioner Levens.
Present.
Quorum present.
If we could all now rise for the Pledge of Allegiance led by Commissioner Hoffman. We'll now have our opening prayer.
Lord who enlightens, we ask for your supernatural wisdom as we make some tough decisions in this meeting. Help us to carefully consider the relevant information that has been gathered, and may those sharing information give us pertinent points so that we all clearly understand. Help us to be innovative as we brainstorm solutions, and help us to wisely evaluate our options, considering the pros and the cons. Help us to be unified in making this best possible decisions and to effectively carry them out. In your glorious name we pray. Amen.
Amen. Now, if I could get a motion to approve the agenda.
So moved. Support.
Moved by Lamore, supported by Levens. Are there questions on the agenda, additions? Seeing none, roll call, please.
Commissioner Asper. Yes. Commissioner Heinzerling.
Yes.
Commissioner Lamore.
Yes.
Commissioner Wenzel.
Yes.
Commissioner Swartout.
Yes.
Commissioner Moore.
Yes.
Commissioner Levens.
Yes.
Commissioner Hoffman.
Yes.
Motion carries.
Next on the agenda is the approval of minutes from the February 3rd meeting. If we could get a motion for that.
I'll make a motion to approve it and waive the reading thereof.
I'll second that.
Moved by Swartout, supported by Huffman. Are there questions, additions, corrections to the minutes? Seeing none, roll call, please.
Commissioner Hoffman.
Yes.
Commissioner Asper.
Yes.
Commissioner Heinzerling.
Yes.
Commissioner Lamore.
Yes.
Commissioner Wenzel.
Yes.
Commissioner Swartout.
Yes.
Commissioner Moore.
Yes.
Commissioner Levens.
Yes.
Motion carries.
We'll now move into our first segment of public comment. Are there citizens who wish to address the board?
Good evening, Lamar Frederick, Bedford Township. Commissioners and Mr. Chairman, I'm here this evening to address the first closed session noted on the agenda, as it involves legal contests between Mr. Brandt and the county. It's proposed to go into closed session to listen to legal advice on how to go forward. I've been in your seats and understand that from time to time, serious issues arise that require decisions that have far-reaching implications. Tonight may be one of them for the citizens of District 4 and the rest of the county. I have had 20 years of personal and legal relationship with Tom Graham and Phil Goldsmith, and we've resolved many pithy issues. I'm sure Mr. Goldsmith will provide the commissioners with the best legal advice consistent with the current standing of the lawsuits. However, citizens only have the information that's been made public. Battles in the newspaper are not legal battles. These cases have gone on far too long. The board has gone into closed session far too many times to discuss the way forward, and all it announces, we agree with the advice of counsel. The decisions have resulted in a standoff. Are we even sure Mr. Brandt wants to settle? Maybe it's time that all the issues and advice be made public so that the citizens of the county have heard all of the legal advice and can make a determination on their own regarding the decisions you make. I know this is dangerous, and it's not often done, but maybe it's time. It's your decision to Mr. Goldsmith or Mr. Graham will give you legal consequences of both options. Transparency and throwing light on the issues is sometimes the best course of action. A long time ago, I was on a telephone hearing with a judge from the South. I made this brilliant argument about the issue that my company was interested in. When I was done, The judge said, Mr. Frederick, are you done? Yes, sir, I am. That dog don't hunt. So you know what happened to my argument. Commissioners, your dog is in the field right now. Will your dog hunt, or will you have to look for another dog? Do you have enough people tonight to go to closed session? Because I've been here before when you didn't have sufficient number of people here to do that. So what is your plan B? And you better have one. Thank you.
Hello, Commissioners. Thank you. Thanks, Chairman Venzel. I'm from District 2, and I can't do much better than that. So I just want to add, I was planning to come tonight because I do read the papers, and I have been tracking what's going on. And so, of course, I was pretty startled to hear that there were mistakes made that are beyond my legal comprehending. But I think when I saw the word settlement on the agenda, that's when I got confused and also super concerned, because to me, a settlement implies that there will be things that are not known to the general public. And I think because we have all been dragged along on this long haul, I really hope that you are fully transparent with us. I did write a note about Mark Brandt's letter of resignation, just a sentence from that letter of resignation back in September of 2024, when he said, "I don't want my personal circumstance to interfere with the smooth operation of the county that I so dearly love." I think that's worth remembering, that he said those things, and yet his personal circumstance has certainly interfered for 2 years now. And he's cost this county dearly in money and in trust. And it does seem to me, one of my questions is, it seems that the only person who's really paid a price for this is Andrea Armstrong, if I'm not mistaken. And I don't get it. So that's why, you've seen me before. I'm here again, and I'm saying the same kinds of things. Another point to remember, I think, when you go into closed session, and if there is some kind of settlement, only 9% of the people who voted in this last election in November, only 9% voted for Brandt's. And if you put that another way, 1 in 10 people, it's less than one person in a group of 10. So that's a rebuke. But the damage, I think, it goes further than Brandt's, and that's where, you as commissioners and leaders really come into play. And we do have to see this county take accountability, even if it's uncomfortable. And the vacuum of information, that's the piece that sows mistrust and doubt and lack of faith in our local government. And we're left with these conjectures and the theories. And that's when things get really bad. We're seeing it. We're seeing it as a country, but here on our local level, people are left to just spin. So I do think that the only way to move forward is by moving through. And my request would be that you would stay the course and return to courts. I know that involves money, but it's really what you owe to the people of District 2 who've been paying the taxes and funding this local government. So I hope you take that into consideration no matter what you decide. Thank you so much.
Are there any other citizens who wish to address the board? Thank you.
Yes, thank you. My name is Helen Corris-Harrigan. I'm a resident of Monroe County. I've been coming to these meetings for a little bit and getting caught up on what's been going on. I'm not a resident of District 2, but I'm here as a concerned Monroe County resident. As we just learned, the Michigan Court of Appeals was clear. The question of who lawfully holds the District 2 seat should have been filed through a quo warranto action. And I'd like to see other people pronounce that tonight because it's a tongue twister. But we've done our research to understand that that is the legal process that challenges whether someone has the legal right to hold public office. Again, we see on today's agenda the words trial/settlement strategy. And I urge the board first to explain the nature of any settlement. And second, to complete the proper legal action to close the matter. My next item is I would urge the board to adopt updated ethics guidelines for commissioners. What we are experiencing now should never happen again. The situation has exposed serious gaps in our county's governance policies. We need clear ethics rules that address what happens when a commissioner is convicted of a felony, standards for financial conflicts of interest, clear disclosure requirements for business activities, and automatic triggers for removal or suspension when legal eligibility is lost. These aren't just theoretical concerns in our county. Strong ethics policies would protect both commissioners and taxpayers. This county has important work to do. Every meeting spent on this unresolved situation is time and money diverted from the people's business. The citizens of Monroe County are watching because we care about our community. We expect our elected officials to follow the law and to act with transparency and to put the public interest first. In summary, I respectfully ask this board to file the quo warranto action to provide transparency on any related investigation, timeline, and process, and to commit to updating ethics guidelines. Thank you for your time and for your service to Monroe County.
Gail Kane, District 8. I've been here before. Tonight, I want to remind you that there is a mission statement. That is one thing that's clear within your little packages of your oath of office, and that you are to perform your legally constituted responsibilities, which is to protect the health, safety, and welfare of the residents of our community and our employees. Now, by community, I'm not talking District 8, I'm talking the county. Sadly, some of our commissioners shouldn't be sitting here, but that's beside the point. You're here, and you have a job, and you took an oath. The board is to demonstrate fiscal responsibility. You're to maintain credibility and to build public trust and assume leadership in the development and improvement of county services and programs. We are spending too much time taking care of District 2 dirty work. The board is to provide the delivery of services through cooperative interaction with all other units of government and community agencies. I too became concerned when I read the words regarding trial/settlement strategy. Closed session is needed if you're going to be discussing strategy. I don't see Mr. Brandt's attorney sitting here and publicly announcing what their next move is to attack the county. You shouldn't have to disclose that at this point in time. If there is a settlement that's being arranged, it's got to be discussed, and I can understand why you would want to do that behind closed doors. But fellas, sooner or later, this has got to come out. We need to hear everything. What we read in the paper, I don't trust anymore. It's not my local news. It's written by people with AI help. I don't understand the legal mumbo jumbo. You have done a good job in what you can do in good faith and on behalf of the well-being. It's sad to think that our clerk of the county is being attacked or brought into this, because I don't think that she at all would intentionally create any harm or put any question into the legalities of how we run elections here. And that's being attacked on all fronts nationwide. And it's very, very disturbing to think that now we're being dragged into that mud. It's time for the county to take care of their business, but at the same time, you've got to make the decision what is in the best judgment for all of us. District 2, has the job to take care of the problem. They must step forward and assume the responsibility to recall by an election those that they do not want to sit in that chair right over there. That's their responsibility, not yours. You can call into question what he has done, and how you were advised is of utmost importance. And it bothers me to think that there is another court out there that's questioning our legal counsel. This is a mess. It's worse than the Honey Pot and Winnie the Pooh. It is a blustery day, and you know what is going to hit the fan. It has already happened. So you need to shake your feet, get this stuff off of you, clean up whatever process you've got in the makings, and let us know what you need us to do. And District 2 needs to step up and take care of business. Thank you.
Are there any other citizens who wish to address the board? Seeing none, we'll move into the next agenda items. Our next three items involve closed sessions. Each closed session needs a separate vote. The voting thresholds for each one are a little bit different. Two of them take 6 to move into closed session. The collective bargaining takes 5. So I'd like to start with the first one and get a motion on the table. And if we need to have a discussion, if we need further explanation from Mr. Goldsmith on this first one, then we'll do it after the motion's made.
Mr. Chairman, I would move that we not go into closed session to discuss this publicly.
Second.
Is there support?
Second.
Moved by Commissioner Moore, supported by Commissioner Asper, to conduct this business in open session. Are now there questions or comments?
I would just say my vote for this would be yes, just because although we're permitted to go into closed session, we're not required to go into closed session. We promised the public transparency on this issue, and I feel it'd be best if we discuss this publicly. And then I also have some legal questions about the Opens Meeting Act 15.268E, which says we can consult with an attorney regarding trial or settlement strategy in connection with specific pending litigation, but only if an open meeting would have detrimental financial effect on the litigating settlement. I don't see any financial effect. No one's being sued in this. So I would maybe make an argue that we can't go into closed session on this.
Other comments or questions? Commissioner Liebens?
Based on Commissioner Moore's most recent comment, maybe this would be something that legal counsel would advise us on their opinion. We're represented by counsel in this matter on the merits of whether we should or not go into closed session and whether we can go in closed session. So I don't know if it's Phil or Tom that wishes to speak to that, Mr. Chairman, but I think before we do a vote, we should hear from the people that we've hired to represent us in this matter.
First question, can we go into closed session? Yes. This is to discuss trial strategy. The opponent on the other side of this lawsuit, Mr. Brandt, is in the room here tonight. So for you to discuss strategy in his presence would be inappropriate. Is there a financial stake at interest? Yes, there is. There is an unresolved issue regarding whether or not Mr. Brandt should be compensated as a county commissioner during the time that he was imprisoned in federal prison. That's an open issue that hasn't yet been decided by the court, so there is a financial interest, and there's always a financial interest for each side of a dispute to consider, and that's the payment of additional attorney fees. So there is a financial stake at issue here, and this would be to discuss strategy in going forward. The words that were used in the agenda comes directly from the Open Meetings Act. That comes from the statute to discuss trial or settlement strategy. So my legal opinion is you have the right to go into closed session. Secondly, should we go into closed session? My legal opinion is yes. If you want to be able to talk about strategy and moving forward, and I want to talk to you about the Court of Appeals decision, there's many facets of that Court of Appeals decision that I believe should be addressed. My recommendation, my legal opinion is A, you have the authority to go into closed session, and B, you should go into closed session to discuss these matters.
Any questions? Yes, Commissioner Asper.
I would just say that from the comments that were made at the podium, it's very clear to me that the constituents have really no idea everything that's gone on from the beginning and what the law is with regard to county commissioners. And some of the comments that were made, I thought, were very interesting because I know what the impressions are that the public is given, but they weren't here a couple of years ago. And what has been happening during this time is we continue to have commissioners who are not advised of what's going on sometimes. And at this point, what ends up going is we go into closed session and then we come out with a vote that some of us are against, but it's represented as if we're all together in this. The original injunction was filed by the county. It was not filed by Mr. Brandt. And there are a lot of laws that have to do with commissioners, whether you like them or not. There are a lot of laws that have to do with commissioners that aren't what you might think or what you might want, but they are the law. And so we have been guided for the last year and a half, in my opinion, not in a good way. I believe that we were not properly counseled, or I won't say we weren't properly counseled because that ends up being an opinion. What I would say is what we were trying to say from the beginning was not followed, and now here we are back at square one, spending more money, getting ready to spend more money. And if we go into closed session and then we come out, then they vote. It doesn't require a 2/3. We end up spending the money. So there are other districts other than District 2 who've been hurt by this. We cannot represent our constituents either.
Any other comments or questions? Just for clarification, it's not a we or a they vote when you come out of closed session. This is a 9-member board, and the beauty of a 9-member board is you collectively make decisions. And all the boards I've served on during my career, doesn't matter whether it's a 5-4 vote or a 5-3 vote or a 6-2 vote. When you come out of that vote, it's the collective decision of the entire board, and the entire board takes responsibility and owns that vote. So it's not a matter, it's unwise to pit they against others on the board that are in the minority at this point, because this is a collective decision. So if there are no other questions, I'm going to call for the vote. Yes.
The other question is the meetings that happen after the meetings. So I think we have to address that if you're going to claim that. If it's the whole board, there should not be meetings after meetings when we have our agenda meetings.
I'm not sure what your accusation is.
Okay, I'm not making an accusation. I'm making an observation that every time we have an agenda meeting, there's usually a meeting before it and there's a meeting after it, and it doesn't include some of us.
What it included the other night were the two leaders of the board, the chairman and the vice chairman, that sought advice from legal counsel on how we were going to move forward on some of these matters, in particular the closed session matters. So that's not a case of going behind the rest of the board.
We should have been talking at the agenda meeting about that. We should have talked at the agenda meeting about that.
We can respectfully disagree on that.
You're right.
Any other comments? Roll call, please.
Commissioner Hoffman?
Yes, we want to go into closed session.
Well,
Motion is for open.
the motion is to go into to stay in open session for this.
No.
Commissioner Asper?
Yes.
Commissioner Heinderling?
No.
Commissioner Lamore?
No.
Commissioner Wenzel?
No.
Commissioner Swartout?
Yes.
Commissioner Moore?
Yes.
Commissioner Levens?
No.
Motion does not carry.
Okay. Now I would entertain a motion to go into closed session on this matter.
So moved. Second time.
Moved by Lamore, supported by Huffman. Are there questions on moving into closed session for the Brandt litigation? Seeing none, roll call, please.
Commissioner Asper?
Would you repeat the motion?
The motion is to move into closed session to consult with county legal counsel regarding trial settlement strategy in connection with specific pending litigation captioned Monroe County and the Monroe County Board of Commissioners versus Mark Brandt. Monroe County and Monroe County Board, Circuit Court Case Number 25-149222CZ, and Mark Brandt versus Monroe County Board of Commissioners, Monroe County Circuit Court Case Number 25-149230-CZ, pursuant to Section 8, 1E of the Open Meetings Act, MCL 15.2681E.
No.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout,
No.
Commissioner Moore,
No.
Commissioner Levens,
Yes.
Commissioner Hoffman.
Yes.
Motion does not carry.
Okay, so what I would suggest is let's move on to the next closed sessions, and then we can make a decision whether we take this up in open session when we come back from the other two closed sessions.
I'll make a motion to go in a closed session regarding the confidential attorney-client communication pursuant to MCL 15.2681H regarding the forensic audit.
Second.
Any questions on this motion? Hearing none, roll call, please.
Commissioner Hoffman,
Yes.
Commissioner Asper,
No.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout,
No.
Commissioner Moore,
No.
Commissioner Levens.
Yes.
Motion does not carry.
Okay, the final closed session request is the closed session to discuss collective bargaining negotiations pursuant to MCL 15.2681C. Could I get a motion for this?
So moved.
Support?
Moved by Lamore, supported by Levens. Are there questions on this motion? Hearing none, roll call, please.
Commissioner Moore,
No.
Commissioner Levens,
Yes.
Commissioner Hoffman,
Yes.
Commissioner Asper,
No.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout.
No.
Motion carries.
Okay, we will now move into closed session for collective bargaining. Oh, that's right. We are going to stay here. No, we're moving. We're moving, so you can stay here.
This is a sad day for Monroe County.
Motion to re-enter open session.
So moved.
Moved by Lamore, supported by Swartout. Any questions on this motion? Roll call, please.
Commissioner Hoffman?
Yes.
Commissioner Asper?
Are we voting on coming back in, or are we voting on the motion?
We're voting on to come
Just
back into open
Coming
session.
into, okay, yes.
It was suggested by legal counsel that we do that.
Commissioner Heinzerling?
Yes.
Commissioner Lamore?
Yes.
Commissioner Wenzel?
Yes.
Commissioner Swartout?
Yes.
Commissioner Moore?
Yes.
Commissioner Levens?
Yes.
Motion carries.
Okay, next up will be what would have been a closed session regarding a consultation with county legal counsel regarding the Brandt litigation. We'll now do an open session. I would like Mr. Goldsmith to come up and begin.
I'm going to.
Mr. Chairman, could I just ask a question quickly? Do we need a vote on to follow advice of counsel from the closed session, or no?
No.
We do not.
No, I asked the labor attorney, he said no motion needed.
Okay, just wanted to double check. I didn't hear that.
Okay, so we didn't make a decision then?
I think we came to agreement.
I don't.
But I think we came to an understanding of what was going to happen.
Well, we didn't ask anyone to do that, because we can't do that in closed session. We can only do that in open session.
Yeah, just anything we've discussed and decisions we made in closed session, we've usually had a vote on that. I just don't know what changed.
In
on this.
open session, yeah.
Could I, well, we can do it then. Could
We
I ask
can't
for
make a decision in
a
closed
motion
session.
to move on the recommendations made in closed session to Human Resources Director Jeff McBee and Labor Counsel? I moved by myself, supported by Lamore. Any questions on this motion?
I just have one comment that anything that comes of our closed session would necessarily come back before the vote of the board for a final vote on how the negotiations conclude, whether it's a yea or nay, because that closed session, as the agenda indicated, was to discuss bargaining negotiations. It wasn't to discuss a final outcome for a yea or nay. This is just proceeding ahead. So I just wanted to clarify it for the audience, because some of the closed session is presenting a little bit of a mystery. So what we're doing today, at least for the closed session bargaining for our employees, is negotiation, and we don't know what those negotiations are going to produce. And when they do, that would be another vote, which would then be on the agenda in its full particulars
That would be an open session.
in open session. I have nothing further, Chairman.
Roll call, please.
Commissioner Heinzerling?
Yes.
Commissioner Lamore?
Yes.
Commissioner Wenzel?
Yes.
Commissioner Swartout?
Yes.
Commissioner Moore?
No.
Commissioner Levens?
Yes.
Commissioner Hoffman?
Yes.
Commissioner Asper?
No.
Motion carries.
Okay, we'll now turn it over to Mr. Goldsmith.
Okay, I'm going to address the Michigan Court of Appeals decision and opinion that was recently released. So it will come as no mystery to this board or to anyone in the public who's been following this that the singular issue that the county presented first to the trial court and then to the Court of Appeals is based on MCL 46.411. And that was recognized by the Court of Appeals in its decision. It's under the heading D, issues that are and are not properly resolved at this time. So the county asked for declaratory judgment, which, with all due respect to the Court of Appeals, was the proper way to go about doing this, because what the county asked for through me as county legal counsel was whether or not on January 1, 2025, Mark Brandt was a qualified elector and thus a registered voter. Because 46, as recognized by the Court of Appeals, they state, the trial court erred when it granted Brandt a declaratory judgment that his incarceration in another state did not act to vacate his seat because the trial court did not address or decide potentially dispositive legal issues raised by the parties below. The court did not decide potentially dispositive legal issues raised by the parties below. The issue that I raised in all the briefing that was done to the Court of Appeals was Mark Brandt on January 1, 2025, a qualified elector? He had not yet taken office at that time. He couldn't take office at that time because he was incarcerated in a federal prison in West Virginia. So the statute, and the Court of Appeals quotes a part of it, a candidate for the office of county commissioner must be a resident and registered voter of the district that he or she seeks to represent and must remain a resident and registered voter to hold his or her office if elected. Mark Brandt never took his office on January 1 because he couldn't take his office, and it is the argument that we put forth to the trial court and to the Court of Appeals that he couldn't take office because he was incarcerated. And so if you rely on 46.411, the two sections of the Michigan Constitution of 1963 that were quoted, and the various statutes that we quoted, which are part of the body of Michigan election law, that was a declaratory action decision. The court, in my view, should have said, and the trial court didn't address it, and the Court of Appeals found fault with the trial court for not addressing it. In my view, the trial court needed to say either he was a qualified elector or he wasn't a qualified elector on January 1. If the court would have, and that's a declaratory judgment, if he wasn't a qualified elector, then he couldn't take office. The second question that I asked the court to decide, if you determine that he was not a qualified elector, does that operate to vacate his entire term of office? I just want to make mention of this. So, what if? Now, Mr. Brandt was sentenced to serve 18 months. He served less than 18 months. But what if he was convicted of a felony that required a 4-year prison sentence? That's what I wanted the court to decide. His inability to take office, does that disqualify him for the entire term or just a portion of the term? If he were in prison for 4 years, the court would have had to answer this question and still has to answer this question. Does that mean that the office remains vacant? If they, in other words, if the court would have answered the question this way, that he was a qualified elector, but he can't serve because you got to be present to serve, does that vacate the office for the entire 4-year period? The court didn't answer those questions. The Court of Appeals found fault with that. So that is a declaratory action type of a judgment that the court didn't make. The Court of Appeals addressed that. With respect to quo warranto, the court finds fault that neither party pled this as a quo warranto action. But interestingly, the court also points out which I raised in my briefing to the Court of Appeals, was whether or not the county was even in the position to raise a quo warranto action. And there's cases on that. There's appellate cases on it, and that's recognized by the Court of Appeals in its decision. When they talk about quo warranto, they raise MCR 3.306B2, which is the quo warranto court rule. They state, which of these procedural hurdles applies in this instance may well depend on the proper interpretation of the phrase, an office in a public corporation created by this state's authority. So to backtrack, that court rule requires a quo warranto action to be brought by a public corporation. And the Court of Appeals properly recognizes that they state specifically, courts have not yet resolved the parameters of this definition. So the Court of Appeals recognizes that, well, maybe even Monroe County, in the context of the quo warranto court rule, is not a public corporation that can even request a quo warranto action or can even request the Attorney General to take on a quo warranto action. They also raise the question of whether or not the County of Monroe is a person that could request the Attorney General to bring a quo warranto action. That's been a little better defined, goes back to a 1971 Court of Appeals decision, so that's been a little bit better defined. So I stand by the way we presented this case because what needed to be answered was on January 1, 2025, was Mr. Brandt a qualified elector? If the court, and unfortunately the trial court didn't address that issue, and I raised that in our cross appeal. So where are we at now? It's been mentioned that, well, you have to, if we're back to ground level here. I would respectfully submit that that is not the case. We're not back to ground level. All the arguments that were made both to the trial court and to the Court of Appeals are arguments that still apply. And really, it's form over substance. Really, all the Court of Appeals wants to do, right, wrong, or indifferent, but we have to do it because that's how they've instructed us to do it, that we have to make an application to the Attorney General, either as a public corporation or as a person. The county would do that, and if you elect to go that direction, and then the Attorney General would have to act on that application. They would have to either A, take it up and decide the underlying legal issue, which is framed as 46.411, or they could decline to take it and say, Monroe County, you file a motion with the trial court seeking leave of court to proceed forward on everything that you've brought before the court before, plus you frame it procedurally, add a count to the complaint of quo warranto under the court rule. So now there's another way that this could happen too. Either party, if they so chose, could file an application for leave to appeal with the Michigan Supreme Court and challenge the Court of Appeals decision and ask the Michigan Supreme Court to grant their application for leave to appeal to decide whether the Court of Appeals was correct in its decision. I'm not advising you to do that, to go in that direction. I think that would be, generally speaking, a waste of time and money to do that. If you're going to go forward, and people talk about settlement, but quite frankly, and it's recognized by the Court of Appeals, I don't know how you settle a case like this. It's been suggested to me by Mr. Brandt's attorneys that, well, the county could just drop its lawsuit, which I suppose Mr. Brandt's lawyers would drop their lawsuit, but it's gone too far at this point. If you remember, when after the trial court, Judge Kuhnke entered her order, I think it was September 12th, after she entered her order, Mr. Brandt's attorneys filed their appeal. And they also filed a motion with that appeal asking the Court of Appeals to, A, enter an injunction that would prevent Monroe County from going forward with the special election. That, by the way, was openly suggested by Judge Kuhnke in her opinion, her September 12th opinion. They asked the court to enjoin, the Court of Appeals to enjoin that special election, and they asked the Court of Appeals to vacate the stay that Judge Kuhnke had put into effect. And the Court of Appeals chose to do neither. The Court of Appeals did not vacate the stay, stating that Mr. Brandt could not serve as a county commissioner during the pendency of the matter, and they chose not to enjoin the special election. And properly so, because they point out that that would have required the joinder of the Monroe County Clerk, who is the election official in Monroe County. This board had the authority under the statute to call for a special election. And you called for a special election because you adopted my legal opinion that 46.411 automatically vacated that position because Mr. Brandt couldn't take office on January 1, 2025. This board didn't, there's been a lot of misconception out there. This board didn't remove Mr. Brandt. You don't have the authority, and I told you you didn't have the authority to remove Mr. Brandt. The legal theory is that by operation of law, since he couldn't take office on January 1 of 25, that office was vacated automatically by operation of law pursuant to MCL 46.411. So, and that is the underlying and the most important legal issue in this whole litigation. So in my view, if this board chooses to go forward to get it properly back in front of the trial court, you would need to authorize me to make an application to the Attorney General, and I will have to carefully craft that because the Court of Appeals pointed out, and I pointed it out to the Court of Appeals in my briefing, that Monroe County may not be a public corporation as it applies to the quo warranto court rule. I'll have to carefully craft that, and that Monroe County is a person as set forth in the court rule, and ask the Attorney General to take it up and make a decision. Now, they could take it up and issue an opinion. The Attorney General, it's not a court. They could issue an opinion on the underlying legal issue, on the issue of quo warranto, as to whether or not that office was automatically vacated by operation of law pursuant to the statute 46.411, or the Attorney General could say, we're not getting involved in that. We decline, and send it back, and then I would file a motion, which I believe Judge Kuhnke would grant, so that we could get it back in front of her as directed by the Court of Appeals. So I don't want to belabor this. I have spent countless hours of my own time thinking about this, but because it's important. It's important to this board, it's important to District 2, it's important to the community, it's important to Mr. Brandt, it's now important to Mr. Benicki. And I guess I'll wind up by saying the court allowed this it was suggested by the trial judge, Judge Kuhnke, that an election go forward and that not be vacated, and that election did go forward. And what happened in that election was Mr. Benicki was chosen by the registered voters of District 2 to be their representative. Now he's involved, and he has certain due process rights that shouldn't be ignored. And so the court's going to have to weigh that. And it's up to him, he may or may not intervene as a party in this action. He may hire his own lawyer and intervene, file a motion to intervene in this action in an effort to protect whatever rights he has under Michigan law, given the chronology of events that have occurred with respect to this case. So he may or may not be in it. That is totally up to him. That's a choice he has to make. But in terms of this whole board, I really don't see how you just say, well, let's settle. This is not like an injury lawsuit where we're talking about, is there liability and is there damages, and if the liability meets the threshold, what should the damages be, and we settle on a damage amount. Not that simple. the legal question still needs to be resolved. I think the legislature should take this up. Commissioner Asper touched on it, I think, in her comments, that there are certain things that you can and you can't do with respect to county commissioners and as they hold their seat. The legislature, in my view, needs to take this issue up. And that boils down to if someone is convicted of a felony and they're in prison, are they a qualified elector? Now, you know, I agree with many things that Mr. Brandt's attorneys have said. For instance, if Mark Brandt wasn't in prison on January 1, 2025, his federal felony conviction would not have stopped him from taking office, because he could have been here and he could have acted as a commissioner. I don't contest that. I concede that. That's a rule of law as it applies to this case. But the fact of the matter is he wasn't. And we didn't know how long he would be in prison, only that he was sentenced to serve an 18-month sentence in federal prison. So, you know, we had to deal, I think this board had to deal with that. Do you just sit on your hands and do nothing and just wait to see how long he's in prison and leave District 2 unrepresented? Right, wrong, or indifferent, I provided you with a legal opinion. I still stand by that legal opinion. No one's going to get me to change my mind on that legal opinion. The court needs to issue its opinion, on its own opinion on that. Maybe I'm right, maybe I'm wrong, or maybe it's somewhere in the middle. We'll find that out, I guess, soon enough if we proceed forward. So, so that's where we're at. Again, I'm probably talking too much, but the decision the board needs to make is, do you go forward with this? Do you allow me to make application to the Attorney General, even though I think it was properly before both courts on a declaratory action on the issue of was he, this is a legal question, was he a qualified elector on the date he was supposed to take office and couldn't take office? But nonetheless, do you allow me to make an application to the Attorney General, setting all the relevant facts in that to see if they'll take it up and they'll make a decision, issue an opinion, and then we go from there. Once that's done, we would have to, Mr. Brandt's a lawyer, and I would have to consult with the judge, probably have a pretrial conference because it's back in front of her and something needs to be done, and let her know that's what's going to happen. Or, for all I know, Mr. Brandt's lawyers could choose to file an application for leave to appeal with the Supreme Court and have them take it up to decide whether the Court of Appeals was right when it issued its opinion, when it found error in the way the judge decided the case with respect to the issues that we, the county, raised, both at the trial court level and at the Court of Appeals. So that's your task tonight from me. Do you proceed forward, allow me to continue the litigation by filing an application to the Attorney General under the quo warranto statute, or something else?
Are there any questions for Mr. Goldsmith? Commissioner Asper?
So really, this goes back farther than January 1st. It goes back to when Mr. Brandt resigned from his previous term. And the way the law reads, the problem with felonies is if you commit the felony after you're elected. The felony that was in question had happened prior to the election. In fact, he was sentenced 5 weeks before the election. So at the time that people voted, it was already out there, 5 weeks that he had been sentenced. And like I say, the felony didn't occur afterward, it was not committed afterward, and it was not committed against the county. The law says that the chair of this board has to appoint somebody within 30 days. Our previous temporary chair chose not to do that because it was closer to the end of the year. and he was going to leave it for the next chair. The next chair did not do that. Against the law, we were supposed to appoint somebody until the first year was passed, and then the people that actually are in District 2 could have gone ahead and voted. As it turns out, they voted in November, 90%? It was like 7,000 votes more than anybody else in that election. So that was pretty decisive. Also, he was the Republican candidate. In this county, some people just vote for the Republican, whoever that is. So I think that's a lot of what explains what happened in this election that just happened. So when the chair of this board did not go ahead and appoint someone, which is not according to the law says we have to do that within 30 days. Also on January 1st, to simply do this theory of not being an elector. An elector, that whole law portion is so that people won't run in a district that they don't belong to, that they're not living there. And it was also said by our clerk that he was duly elected, and he was also sworn in, which means we have 2 people that have been sworn in. So when that wasn't done, and when they decided, and as of the 1st of January, he was still getting requests for appointments. And those appointments actually did come back. So he was being treated as a commissioner from that point. I don't even think the payment thing even came in until about mid-January. We've had commissioners who we didn't even know where they were. And they ended up being off this board, not being able to be here for 6 months. So it's not a matter of whether you can actually be here. I saw emails where he wanted to actually do things from where he was staying. It was one of those type of prisons where you don't have fences and things like that. So he was refused to have communication because the chair would not communicate with him by email. So that's another thing. And then we go to say, I guess they figured, oh, well, yeah, we don't have the right to unseat him. In fact, Kunke, her ruling was that he did not vacate the seat. The way that a commissioner vacates a seat is 2 ways. One is if they resign, and the other is if they move out of the district. So they have to be off because they aren't an elector. It was determined in your writing that he had not given up his residency. When he came back here, he was still registered to vote. So all these things were a theory. We went forward with a theory. And then when he got out of prison, which I have to say, he accomplished more in those 8 months than we've accomplished in the last year, which is sad to say. Then when he came back, he could have sat down on the board. Well, so he did. And when he sat down here, we back up to what happened, and I'm just saying this because the audience doesn't know all this other part of it. They haven't read the law. I'm not a lawyer, but my eyeballs are about blind from reading what's actually in the law. And what ended up happening was they were going to do a special election in May. And of course, we can't have a special election in May because it's a partisan election, so it couldn't be until August. And then when we got we were supposed to even make up our ballots, but because there couldn't be this decision in time, and the thing was, it was an injunction that was filed by the county after we had already decided that he could sit here because the chair had said that he could sit here and nobody made any motions otherwise. And he was supposed to be able to sit here, according to the chair, he was supposed to be able to sit here until that got decided in court. Well, then when that injunction was filed, which we never voted to have him not sit here, we did not ask you to file something that would prevent him from sitting up here. The people in his district could have just chosen to recall him. You wait a year, you recall that person. That is the way that it normally goes. But by virtue of the fact that this board did not appoint somebody when it first got vacated and did not appoint somebody when the new chair came, I think we have to take some responsibility for that. And there are people on this board that voted against that. We just wanted to let it play out so that that District 2 could decide who was going to be their commissioner. But the election we just had, you know, Commissioner Brandt he had been the Republican, and he was duly elected according to our clerk. And so I just feel like there's a lot of complications here, and we went through this, and our problem was that she went ahead and she made the decision that he did not vacate the seat, and then she says, oh, but we're going to let this election go on. We're going to wait and see if you guys want to appeal or whatever. So I am just so discouraged that we did not go ahead and do it the right way, either appoint somebody, and then when he came back, they could decide if that's what they were going to do or if they were going to recall him. I think the constituents in the district are the ones that are supposed to make the decision, but there were some people that did not want that particular possibility, and that's where we got where we got. So afterward, if you have any questions, there's just a lot of assumptions that are being made because of the way things were filed, and people don't know the law, and I don't think we should have gone ahead on a theory. I think we should have gone according to the law and done the appointment.
We did go according to the law, MCL 46.411, and it's much more than a theory. It's coupled with the Constitution and Michigan election law, and it's a matter of first impression to the court, and the court recognized it. The Court of Appeals recognized it, Commissioner Asper. They stated in their opinion, the trial court erred when it granted Brandt a declaratory judgment that his incarceration in another state did not act to vacate his seat because the trial court did not address or decide potentially dispositive legal issues raised by the parties below. Specifically, the trial court neither addressed nor decided cross-appellants, that's us, the county, argument that Brandt's incarceration in another state resulted in a vacancy of his seat automatically by operation of law under MCL 46.411. So I didn't just grab something out of thin air. A lot of time, research, and thought went into this. And this is a question of important jurisprudence to the state. This is a question that needs to be answered, and it's a declaratory judgment type question. And someday, I hope a court answers this. They may say, you're wrong, Goldsmith. He was a qualified elector, which, as Judge Kuhnke said in her opinion, would be nonsensical to me, because then you could have somebody elected and then not be able to serve for their entire term, and then that with a county commissioner, that just sits vacant for 4 years. So with respect to what happened in 2024, that and I don't challenge that. I don't contest that. Mr. Brandt was obligated. His office was vacated because he was sentenced to a felony offense. Not a felony that was committed that had anything to do with his commissioner duties. Totally outside of that. That was something personal. I don't want anybody to think that he committed a felony that had anything to do with his operation as a county commissioner. He did not. If it would have been that, he wouldn't have been able to run for office in 2024 to be elected to start the 4-year term January 1 of 2025. So he decided on his own to resign. That's correct. A decision was made, and I think it was based on past precedent. I think that since they were close to the term, the end of the term, that an appointment wouldn't have been made. I think that the rationale for that, it's been stated by Chairman Wenzel in the past, the rationale for that was that there's a very short period of time between now and the end of the year to appoint someone to fill that position would potentially give them a leg up in the next election. Chose not to do that, let the people make that decision in the November the November 2024 election. So that was done, and that's the way it proceeded. So was Mark Brandt legally on the ballot in November of 24? Yes, he was. Did he get elected? Yes, he did. The question is, and if the judge would have put him on probation and he was able to come and sit at his seat and do the work of the county, none of this would have come up, because that's the way the law is. You can be convicted of a felony if it's not in your term of office and continue to serve, unless it's a felony that's connected to the business of you being a county commissioner. So it all boils down to this. I keep coming back to this, but this is where we're at. On January 1, 2025, he couldn't take office because he was in prison. The law is clear. A county commissioner can only do the business of a county commissioner at a meeting open to the public. The Attorney General has offered opinions on that. I agree with those opinions. I cited them in my briefs, multiple briefs to the Court of Appeals and to the trial court. You have to be present to do the business of a county commissioner. You can't do that through a third party. You can't do that by email. There was only a limited period of time where commissioners could appear remotely during COVID. That time has now passed. So it comes back to this legal issue. Was he or was he not a qualified elector on that date? You and I respect your opinion, you know that. I think you respect me and my opinions, and will respectfully agree to disagree on this. And that point is that the law, in my mind, wasn't 46.411 has a lot deeper meaning whether or not you're in your district or not in your district, whether you move from your district, if he voluntarily moved. So if you're not there and you're not a qualified elector on that date, you can't serve. So the court needs to decide that issue. Simple as that. The court needs to decide.
But what you're saying is that that you can disregard the law when it says that a person has to be appointed within 30 days. So that was disregarded. You don't just get to say that, I mean, it wasn't Chairman Bensel that made that decision in 24. It was actually given over to him because he was going to become, whoever was going to become the chair, but he became the chair in January. And I'm just thinking that I can't just make a decision that I want to do something if it's in the law that you're supposed to appoint somebody. That's the problem. The other thing is what if I had COVID, and I couldn't have come to my meeting or whatever? As it turns out in the law, sadly, commissioners don't have any kind of attendance policy. You can censure them, you can do other things like that, but technically, because we had a commissioner who missed 6 months and could not be here, and we had another commissioner who wasn't here for 2 months, I mean, if we don't have an attendance policy, I don't really see how that applies. I mean, it's sad. I think we should have some sort of attendance policy, but basically all you can do is censure, and some people don't care about that. So it just seems to me that the law is being, applied whether we want to use it or not. And if it says 30 days and you have to appoint somebody, you have to appoint somebody. And that's how we originally got Chairman Bensel on the Board of Commissioners, was he was appointed, and then we had an election and he was elected. So, so the precedent on this board has been to replace somebody if they had to resign, which the previous commissioner had to resign. So I just feel like we took it out of their hands because there were people that did not want the outcome to be a certain way. So that's the sad thing right there.
Mr. Goldsmith, can I ask just a couple of clarifying questions?
Sure.
When former Commissioner Brandt entered a guilty plea in March, was he legally obligated to let the board know that he'd entered a guilty plea? And was he at that point ineligible to hold office, and was he required to resign?
He was, by law, when his case was fully adjudicated, which was when he was sentenced, which came after that March date, when his case was fully adjudicated, because he could have withdrawn his plea, any number of things could happen. But when he was fully adjudicated and sentenced on the crime, then he was obligated to let the commission know and to resign pursuant to that statute.
And so during the
203.
during the period of time from March when he pled guilty until the sentencing in September, he was legal to sit on this board and make decisions and vote on issues.
There's the prevailing legal position is your case is not fully adjudicated until you're sentenced. Once you're sentenced and the case is fully adjudicated and appellate rights have been in most cases curtailed, then he should have, in my view, he should have resigned, because really the statute says your office is vacated because of the felony conviction. It talks, there again, these statutes are old. These go back into the 1800s, early 1900s, when counties were run by county boards of supervisors, which were comprised of the supervisors of the respective townships throughout the county. These are old statutes, still good law today. I think they need to be reviewed by the state legislature, but his office was vacated when he was fully adjudicated on that felony offense, which the law has interpreted by Supreme Court decision that an infamous crime, a felony is an infamous crime. So, long answer to your question. I hope I answered it.
And when he pled guilty in September, then according to Commissioner Asper, the then chair, acting chair, had an obligation to appoint. Is that correct?
Not the chair, the board, but the way the statute reads is if the board doesn't appoint someone within 30 days, then there is an election. Then you call for an election. Well, there was no point in having an election at that point. There couldn't have been an election at that point because the term of office ended December 31st. So either or. If you had a vacancy, you could choose not to appoint somebody. You don't have to appoint somebody. If you don't appoint somebody, then an election has to occur.
And so that wasn't necessarily breaking the law when an appointment wasn't made?
Not in my view. You know, it's if you make a decision not to appoint someone, then it defaults to the election. And as far as a recall, I would simply say this. You can't recall somebody in their first year of term. You can't recall somebody in the last year of their term. So the legal question was always out there. When Mr. Brandt's term didn't start because he wasn't able to take office on the day he was supposed to take office. So when does that year start and when does it end? Court hasn't answered that question yet. If the court comes back and says, that Goldsmith, you're wrong, he was a qualified elector on January 1, 2025, even though he couldn't be here due to his imprisonment, you're wrong on that. Well, then most would take the legal position that the 1 year of service began on January 1, even though he wasn't here and unable to serve, and it goes to December 31st. And now, if a petition, if the people of District 2 wanted to circulate a petition, they could.
Just a, oh, did you have something to say?
No, I'm talking to the administrator.
Just three quick questions for you then, because you bring that up, and I just wanted to read this part of the appeals court ruling and tell me if I'm understanding this correctly. It says, because those issues were raised by the parties below, they both would ordinarily be preserved for appellate review, despite the trial court's failure to actually rule on them. And then it gives some language for that. And then below that, it says the procedural flaws in this case are a direct result of both parties' failure to properly plead and argue their claims and to name the proper party defendants in the trial court. So it's sounding to me like the appeals court said, even though the trial court didn't bring up the specific things that you're asking me to appeal, they could have had appellate review on this. But both parties are to blame for not properly trying this in the right court. Is that what it's essentially saying?
No, I think you're
Okay, what is it saying?
misunderstanding. So when you talk about the county joined the proper parties, when they talk about proper parties not being joined, they're talking about Mark Brandt's claim when he asked the Court of Appeals to enjoin the county from going forward with the special election. In order to do that, they would have had to add parties. They would have had to add the Monroe County Clerk, because the Monroe County Clerk is the one who oversees elections. So, and they say that Brandt's lawyers should have brought a mandamus action if they wanted to enjoin the election, the special election that happened in November of this year. So that's what that was about. The county named the proper party being Mark Brandt.
I guess I was wondering on that line, the procedural flaws in these cases are a direct result of the parties. So what parties, they're plural, are they talking about?
They say County of Monroe and Mark Brandt, you both should have added a count to your respective complaints under quo warranto. That's what they're saying.
Okay.
They said you both didn't do that. You should have. I respectfully disagree with that, because I keep hitting this. The question is, it's somewhat complicated, but on the other hand, to me, it's not. Was he a qualified elector on January 1?
Right.
That's a declaratory judgment issue.
so that-
was he a qualified elector?
In your
That
legal
question-
opinion was that he wasn't, correct? So then why was your office sending him recommendations for boards to his prison email?
Because that was prior to my legal opinion my legal opinion was requested. That was done prior to my legal opinion being authored, where I set out for the board 46.411, the Constitution provisions and the election law provisions. That was done prior.
So your natural assumption was he still was. Before you gave your legal opinion, then your office was acting in the natural assumption that he still was a county commissioner by requesting him to fill board seats.
I wouldn't, it wasn't my natural inclination. I was researching it. So no decision had been made yet as to how we were going to advise the board. And, you know, some people have suggested that that my work was done. I was given an assignment. We want you to reach this point. And so do whatever you need to do to get to that point. And so I told you guys before, and ladies, if you would have asked me to do that, I use these words, I would have told you to go jump in the lake. I'm not going to do that. I'm going to research it thoroughly and come up with an opinion that I have faith in and I believe is well grounded in the law. So that was never done to reach a point and just come up with some theory. I didn't do that. I researched the law. I considered it very thoughtfully, and I came up with my opinion.
No, I'm sure you did.
I had not made a decision at the point that was taking place. I think at that point, there were many people reaching out to my partner Tom Grant saying, on these boards and commissions, we have to have somebody act in this capacity. What do? We have to have somebody act in this capacity. So he did what he did while I was researching. I came up with my opinion based on the law. That's how that happened. So I'm not going to sugarcoat it. That's how it happened. Those are the facts.
And then my last question would be, so what if the county does absolutely nothing? What's the next step? It's pretty much up in the air, right? I know you said we're not back to square one, but it sounds like the appellate court said, hey, this needs to be filed properly like you explained. Where, in your legal opinion, where are we at if the county throws their hands up and let's just says, we're not acting at all? We're never bringing up this subject again. Let's just say that happens. Where would that, in your legal opinion, where would that leave us?
The legal question would never be answered. It would leave Mr. Banicki in limbo because of the course of this litigation. He may choose to challenge that in court. The only way that could be done, Greg, I think, is if you chose collectively as a board, is to just throw up your hands and say, that, we know you sent this back to us, Court of Appeals, for more litigation, more action in front of the trial court. We're just gonna dismiss our complaint and be done with it. Still doesn't answer the question, though, because a lot has happened since that time, primarily the special election. And I go back to this point, the Court of Appeals, and we would have honored it, the Court of Appeals had the opportunity to address it at that point, and they said at that point, we're not, the election goes on, and they gave a rationale for allowing the election to go on. And that was a continuation of what Judge Kunke had stated in her judgment, in her order. I think it would create a larger mess than what we have. We don't have an answer. You could tell me collectively as a board, just dismiss the case, and we're not going to pursue it any further. But
I'm saying, what are the ramifications if there's two people up here wanting to sit in the same seat? What's the next step after that? That's if we dismiss.
Well, this is right off the top of my head.
Okay.
So I would think that Mr. Benicki would, because he would then have a quo warranto action, because he's claiming the office, and now Mark Brandt's claiming the office. So you have two competing claimants. So he could go to the Attorney General as a person.
Who's he?
Mr. Benicki.
Okay.
3.306B, MCR 3.306B. He could, through an attorney, if he chose, ask for a quo warranto opinion from the Attorney General. The Attorney General might give that, or they might send it back and say, you go to circuit court, you litigate it in circuit court. He could do that. Mark Brandt would probably be happy if the board said, wave the white flag and say, we're just going to dismiss our cause of action.
I resent that interpretation, because you're basically, you're basically saying, oh, you're putting up the white flag. All I can say is it's sad that our prior chair accomplished more in prison than this entire board has in the last year. There have been all kinds of stuff talked about. We haven't talked about data centers. We haven't talked about carbon sequestration. We haven't talked about solar panels and all that, maybe this much. The things that people really care about that are going on in this county. And we had this chair who actually ran this board without drama, and we accomplished things. And we were in a very good financial situation. And we are still, thank God, because of some of those plans. But throwing up the white flag is hardly what I would call putting Mark Brandt back on this board.
Throwing up the white flag means you're giving up the claims that have been raised in the litigation. So,
Well, I
am not here to challenge or contest the job that Mr. Brandt did while he was on this board. Not for 1 second. I think Mark Brandt served the community well when he was on this board.
I have one more question.
Your
for
initial letter, though, your initial
but-
letter told us to go to a higher court, that's what you told us to do. And then after a while, what it turned into was a theory that he wasn't an elector, and it went a totally different direction. Why didn't you keep persisting to say, no, you've got to go to a higher court? Why did it turn into this other thing? That's what I don't understand. That's what I don't understand.
You look at my legal opinion. My legal opinion is based entirely on MCL 46.411, the Constitution and the same statutes that I pled in the trial court, and that the trial court was asked to answer and didn't, and that was recognized by the Court of Appeals. She committed error because she didn't answer those questions. So I didn't change in midstream. Not,
Mr.
you know,
Chair,
not
can I
from a
interrupt
bit.
just for a second?
Commissioner
I
Levens?
think we've got an excellent statement of where we were, how we got to where we are now from our county's attorney. I think we've had a great counterpoint from Commissioners Asper and Moore. I think everybody in the audience here today, watching us electronically in real time or in the future, is pretty much surmised based on the preceding votes that got us here, where the board is essentially positioned on this topic. But to move it forward, I would just ask council really quick, what is your recommendation based on where we're at now as our retained Monroe County Board of Commissioners council moving forward? What is it that you're asking for the board to do right now?
Well, the decision of the board is whether or not to proceed forward as directed by the Court of Appeals, and to, in my view, to proceed forward, you would file an application for.
And not to interrupt, but what is your recommendation?
Well, I mean, this has to be brought to a conclusion. So I would recommend that you allow me to file an application with the Attorney General as suggested by the Court of Appeals in its decision and order. The Attorney General will then have to decide to take it up or not take it up. If they take it up, they'll presumably issue an opinion. If they don't take it up, then it comes back.
I make the motion
Wait,
based on the
I didn't hear what he
recommendation.
said. If they don't take it up, what?
If they don't take it up, then it comes back, and then I file a motion with the trial court asking the trial court for leave to add a quo warranto count, and then the trial court decides the issue. And based on their decision, either Mr. Brandt takes it back up or the county takes it back up to the Court of Appeals.
And then can I just ask one quick question before you finish your motion?
Of course.
I don't want to belabor it. I know we've been here a long time. So in your opinion, that would be a better option than doing nothing and having those two guys fight it out? Essentially, I know that sounds rough, but it's like, hey, you two want to figure it out in court? Go figure it out. Now, both ways leave District 2 unrepresented. In your opinion, which one do you think would be quicker to get to a resolution? Going through the state attorney general, then them either having pick it up or not. If they don't, it goes back to a trial court. We have to go through that again. Could we be looking, if we go the route of sending it to the state, could we be looking at another year and a half? I know we thought this thing was going to get resolved in a few months. We're now 18 months in. Well, not the court part of it, but a year in. What's your legal opinion there of like the timeline? Because I'm also worried about District 2 getting representation.
Sure.
No matter who it is.
Sure.
Could
To answer your question, Greg, it would be quicker for us to do it because we can get it in front of the Attorney General quickly. They'd have to do the same thing. If Mr. Benicki chose to do that, he'd have to make application to the Attorney General. They'd make a decision. So he'd be starting fresh. We've got everything. We send it, we file the application with the Attorney General. We wait for their opinion. I can't answer the question of how long it would take. I thought the Court of Appeals would have given us this answer months ago. They didn't. And the reason I thought that is because right off the bat, when the appeal was filed by Mr. Brandt, then we filed a cross appeal, and the Court of Appeals said, we're going to submit this on the briefs, and we're going to decide that because of the exigencies involved with the election, we're going to decide this without oral argument on the briefs. And we waited. I think the trial judge thought I think the trial judge thought that the Court of Appeals may have made a decision even before the election. But we filed everything timely. Nobody asked for any extensions. Crying out loud, Mark's lawyers filed a motion at 12 noon on a Thursday. I get a call from the Court of Appeals, a motion and a brief. I get a call from the Court of Appeals saying, we want your response at 8 a.m. tomorrow. I said, may I have until 10 a.m.? I stayed all night, I did it, and got it filed timely. So, I mean, we did exactly what they asked us to do.
I just have two quick questions. One, it sounds like you've you've got a question yourself on which way to pursue going forward on the way you do the request?
No,
Okay,
no, I mean, it's, even the Court of Appeals recognized that there's no published precedent on whether a county, in view of MCR 3.306B, the quo warranto statute, is a public corporation within that context. So I'll have to address that. I'll have to address the person issue. The person issue, there's a 1971 Court of Appeals decision that's pretty well on point on that. So I think I can get it in front of them, and then the Attorney General is going to have to make a decision.
and one other
So-
thing.
Go ahead.
Is there an option to have one of our legislators make the request for the opinion from the Attorney General?
It has to be by application, and you know, the legislator, if they chose, could encourage the Attorney General, say, hey, Monroe County or Mark Brandt, if they do it, they've made this application for quo warranto. Would you encourage the Attorney General to look at it and give a swift decision?
That's where I was going, because I don't want this to get dragged out.
Well, none of us
Who
do.
does? Who does?
None of us
Well,
do.
since the whole case is about whether or not the seat was vacated, and we did not remove him because we couldn't remove him, then, and since the judge, when she ruled, she said that the seat had not been vacated, and there hasn't been any precedent about a commissioner being, vacating a seat in this manner. It just seems to me like we could at least have him seated to take care of his district until it's decided. Since it hasn't been decided that he vacated it, then why wasn't he allowed to sit up here? And he came up here initially when he first came out, and he actually was doing stuff for his constituents. He settled a dispute in his district probably the first day out or something. It just seems to me that if it hasn't been decided that his seat was vacated, I just don't see how we can be holding off on District 2 having somebody in there. I am willing, I've always been willing to take their calls, and we make decisions that are for the entire county, so I guess technically they're not without representation. But it just seems to me like he should be able to go ahead and be in that seat if it has not definitively been decided and there's no precedent on it. So, and we could have done that last year.
I'm going to ask that Commissioner Liebens was going to make a motion.
I'll make a motion to follow the advice of counsel as indicated on the record.
I'll second that.
Moved by Liebens, supported by Huffman. Now, any additional comments or questions?
All I want to say is, if this character would get up and leave and give the county back to us and let the new man up here, we could put this whole thing to bed tonight instead of going on crazy. If he had the guts to get up and get out of here, which he should, and Mr. Benicki come up here, we go on with the county and do our business. This is all madness. I don't know. You're
Our
in the
clerk
history books
said he
already
was
over there.
duly
What else do
elected.
you want?
Our clerk
else do
said
you
he
want?
was duly elected.
Any other comments or questions? Hearing none, roll call, please.
Stupid.
Commissioner Hoffman,
Yes.
Commissioner Asper,
No.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout,
No?
Commissioner Moore,
No.
Commissioner Liebens.
Yes.
Motion carries.
Yeah. You want me to stay up here for the next one?
Please.
Okay. Do I have to?
Our next item that was originally supposed to be discussed in closed session is the communication pursuant to regarding the forensic audit. And I will turn that over to Mr. Goldsmith.
So, you have all been provided with a MIDC billing analysis that was performed by Plant Moran. It's a forensic analysis that focuses on the, within the scope that you provided Plant Moran, you wanted Plant Moran to investigate the billing practices of one of the MIDC counsel, one of the MIDC attorneys. And so I received that late on Friday. and then spoke with Chairman Wenzel and provided that electronically to all of you. I hope that all of you have had the opportunity to review that. But the long and short of it is that this billing analysis shows, based on the investigation of Plant Moran, that there were improper billing practices employed by the MIDC attorney here in Monroe County that resulted in overbilling, and it's straightforward. I read it carefully. I looked at all the charts and the graphs that were provided, and so it's pretty compelling that this attorney took liberty with the way he billed for the work he performed. And Plant Moran, I don't think, matter of fact, I know they weren't unable to come up with a dollar amount, but they showed over the course of their investigation, within the time parameters that they were, that was the scope of their investigative authority, they showed the billing practices, which the county appears to have been grossly overbilled for work performed. It doesn't address the sufficiency of the legal work. I don't think it was ever intended to do that. It just, the billing practices and the hours and with intensive hours that were billed shows extraordinary time spent on many days. So I think that this board has to decide what to do next, and there are a number of things that can be done with respect to this. One, it could be, I think this report should be sent to the MIDC because the state and that agency has oversight, and they need to be aware of that. And this will assist them in their oversight of indigent defense council operation. It will help them, I think. And it's been suggested that maybe it should be sent to the Attorney General to take a look at it in terms of whether or not there are any violations that the Attorney General might see fit to pursue. And lastly, it's been suggested that, and the forensic consultant indicated a couple of different ethics provisions that perhaps have been violated. So it should be sent to the Attorney Grievance Commission for their review. What they do with it is up to them. What the Attorney General does with it is up to them. And what the MIDC at the state level does with it, it's up to them. But it's really a pretty sad report on the billing practices of this one attorney.
And also that a copy of this report go to the Sixth Amendment feasibility study.
Yes, yeah, because they're investigating at the request of the county and with MIDC, they're investigating, would it be in the best interest of Monroe County? I think part of the scope of their investigation is, would it be in the best interest of Monroe County to continue the current practice of assigned counsel, or would it be in the best interest of Monroe County to consider a public defender's office? And there's a lot of moving parts with all of that, and there's a lot of financial considerations with all of that. But I think it would be appropriate to send it to them as well.
Mr. Chairman?
Yes.
Given the indication of the report that we have in its executive summary, it went through some highlight portions concerning overbilling patterns, recalculation of hours using the attorney's provided corrections, and interestingly, in those corrections, days that were in excess of 24 hours actually increased, and this is no longer trend because we're doing this in open session. These documents are no longer covered by attorney-client privilege. These are now public documents, correct, Mr. Goldsmith?
Correct.
And so it indicated now there's one day that was billed 28.6 hours. I think we'd all love to have a 28.6 hour day to get all the things we want to get done in a day. So there was that. Problematic so-called block and bundled billing, duplicative billings, and not a couple, but over 150 duplicate billings for just the small segment. And to put it in perspective, this wasn't an anomaly of a few dollars. It wasn't even $100, $1,000, $10,000, $100,000, $200, $300, $400, $500. This is over $600,000 that went to the, and this is something that the chairman, myself, and other members of this board railed upon when we saw these claims coming through. And the more that our staff ignored it and slow walked us and refused to acknowledge something because of arrogance, hubris, or whatever it is that they had that made it impossible for them to see what was going on, it exceeded over $500,000. And again, this isn't saying that the work that was actually done, whatever that number might ever be surmised, because of how horrible the bills that were coming up to this board, like bills are going to come up again in a few moments that we're going to have to approve. But I'm not going to approve them based on this. Chronologically impossible charges for billing things in times when chronologically impossible. Accuracy and procedural considerations that completely were ignored. And finally, some other things that go into the weeds of it. So based on that, I'm going to make the motion that it is referred to the organizations and agencies that council recommended. That was MIDC. That's a nod, yes.
Yes.
The Attorney General's correct?
Yes.
This Sixth Amendment, and that's the independent study on whether we proceed to a public defender's office.
Yes.
And then finally, the Attorney Grievance Commission for their professional route, and that was based. That's not based on your recommendation. That's not based on mine. That's not based on any member of the board or a citizen here that came and said, "Yeah, this is from the actuaries themselves that said that because that makes all attorneys cringe."
Well, and so when the actuaries mentioned that, you and I, as attorneys, have an obligation under our ethics code
and I'm glad that you steal my thunder, because this brings me no joy whatsoever. But at the same time, I'm not going to shirk my fiduciary responsibilities, my ethical because the Michigan Rules of Professional Conduct, we are mandatory reporters. When we see something like this, we can't hide it. We can't conceal it. Put on. I mean, we have a duty. Is that accurate?
Yes. We're
And
not
does this
going to, we're
report-
not going to offer an opinion. We're going to submit it to them and let them do with it
But
what they will.
based on this, our hands are kind of tied. When something of this nature comes before us, we have an affirmative duty to advance it.
You are correct.
So,
that motion, too.
so I make that motion. I also, from the folks, my former, predecessor in Bedford, asking for transparency. Ms. Piedmont's been here more times than I can count on one hand, maybe more times than two hands. There have been some other members that say, hey, including the three down there, that we're going to do this in open session. I'm going to ask also my motion that this report be put on our website for anybody to know what tens of thousands of dollars of unnecessary forensic accounting produced that could have been avoided had our staff done their job additionally a year ago. That's my motion.
I'll second that.
Moved by Levin, supported by Huffman. Any comments on the motion? Questions? Commissioner Asper?
So, in other words, we don't have a figure. We paid for the forensic audit. We paid for additional forensic auditing. We don't have a figure. When we do all of this, is there any money that will be coming back to us, or is somebody going to be deciding anything that money would be given back to Monroe County? And I also would like to say that, fortunately, at least this attorney, my understanding is that he was doing indigent defense back when they got peanuts for it. And I really think one of the problems is just that some of the attorneys in this county don't believe their defense attorneys, they don't believe that that they should owe the county some sort of service for the indigent population. So there are some other things that go into this as well, but I just feel like we spent all this money and now we don't, is there any way through these 4 agencies that you're talking about us sending this to that we actually get this money reimbursed? Do we have a number?
May I interrupt? The reason why I endorse the recommendations is so that the county doesn't hemorrhage any more money on this, that we send it to
Is he still working for us?
I can't speak to that. All I
No.
can say is,
He hasn't been working for us. So I just want to know the bottom line. I want to know how much money, if we spent all this money for a forensic audit, how much money are we owed? They didn't determine that. That's not part of it. So we weren't ever going to find out how much money would come back to the county.
we had
We're
to be
just going to punish this
fiscally
person.
Responsible, and I don't want to get into the weeds of it too much, but this analysis, you're talking about maybe if this had been taken with seriousness when it was first brought to everyone's attention, it wouldn't have been such a gargantuan project. But this isn't 1 week, 1 month. This continued over a year. And so, as you recall, when this was engaged, it was a snapshot that was going to be reviewed. And so the numbers, and it's in this report, tens of thousands of dollars that are double billing, so on and so forth. But my position, based on counsel, this report, and the rest, is that we stop the hemorrhaging and have the folks that are situated in charge to take it the rest of the way, and we've done our job. So that way we're not spending tens and thousands more on all of these forensic and other things that take us away from our business. Our job as a fiduciary to have these bills come before us. They were taken on the assumption that they've been properly vetted and presented and just ready for our approval.
And of course, when we had it investigated, or I should say reviewed by Raymond, we thought that was going to be a forensic audit, and then we found out later, no, that actually hadn't been a forensic audit, so you needed to do that. And I was the one that required us to get Raymond here to actually do the report because I don't like secondhand information. And then that's when we found out that it actually wasn't a forensic audit, and we were going to have to get somebody else because Raymond wouldn't do it. So we keep spending this money, but I don't see that it's, we need to. If there was money that was taken from us improperly, there should be a pathway back here. So we can go ahead and spend all this stuff, sending these things out to these other agencies, which obviously it has to be done. But I just want to know, is there a way to retrieve some of this money? I mean, in fact, even Plant Moran said that they don't make judgments on this. They just, give you an idea of patterns. So, but still, I don't see anything about us getting any money
The
back.
bigger issue is that this model has to be fixed. I mean, you're going to see on the bills tonight that there are some claims that are $27,000, $22,000, and there's no way for us to know, is this a monthly claim? Is this a quarterly claim? And those were concerns that were supposed to be addressed, but they don't seem to get addressed. And so more than, I agree with Commissioner Liebens, we need to stop the hemorrhaging, but we need to fix a broken model here of how we deliver a defense for the indigent. And so there was no way around this other than for us to proceed the way we did, which was to take the initial findings and recommendations from Raymond, take it a step further with Plant
Because they
Moran
would
with a
not.
forensic audit, and they've done their work, and now it's our obligation to turn it over to let other agencies do their work.
I know, but what a lot of this came about was because you want to do the defense a different way. And the problem is, when I first got on this board 9 years ago, I was all for having public defender's office and so forth, and then I looked into it. And in everything that I've seen, it has been this, basically if we were a lousy county that couldn't meet the qualifications of being able to, properly do defense and so forth, then the MIDC would say, okay, you're going to have a public defender. But it's always been a lesser thing. We have extraordinary people that work for us, extraordinary people. Plus, we would have
we have with this county right here.
First of
I'm
all,
just-
We don't have an amount, though, I
it's
think. is
it's
what
never
you're
our
saying.
Right,
decision.
we don't
It's-
have an
it's-
amount,
It's not going to
and-
be our decision,
And it
Commissioner
wasn't
Aspin.
us, it was supposedly staff, so I don't know.
Could I ask the motion maker, because essentially we have three different issues there, and I'm wondering if you'd break your motion up into two and one. Because sending it to MIDC, I'm fine with. Sending it to the Attorney General, I'm fine with. But Trojan horsing in, oh, and by the way, we're going to send this to a group to study us switching over to a public defender's office, I think that's a totally separate issue. And I wouldn't be comfortable voting yes on this, on that one issue, but I'm totally comfortable on voting on the other two issues. So could we break that up into, I mean, it's two totally separate issues in my mind.
So you don't want the firm that's doing the feasibility study to determine whether or not we should possibly change models to have the information
Not
from this
until this
forensic
gets to
audit?
MIDC and the Attorney General and they make a decision on it, yeah.
Exactly.
Okay, well,
Yeah, that-
he made the motion, we have support for the motion. If there's no other comments,
Would
I'd
you
like to call
accept
for
an
the vote.
amendment?
Would he accept an amendment just to
No,
make that a
Not
separate
this
motion?
time, no.
No, let's call for the vote. Roll call, please.
You all see what's going on here.
Did
then.
he just say call the question?
We're going to vote.
You need a second on that, and that's a
We
two-thirds
we
vote.
did.
Okay. Sounded like it.
Roll call.
Commissioner Swartout,
Yes.
Commissioner Moore,
No.
Commissioner Levens,
Yes.
Commissioner Hoffman,
Yes.
Commissioner Asper,
No.
Commissioner Heinderling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel.
Yes.
Motion carries.
Thank you, Mr. Goldsmith.
You're welcome.
Do we have the CASA presentation? Next on the agenda is the resolution, special tributes and presentation, and our CASA presentation. Are we moving forward with that?
Courtesy and respect to them, they'll reschedule, Mr. Chairman, so they needed to move on. So
Tell them thank you.
I took it upon myself to just
I
allow them to excuse themselves.
I appreciate it. Thank you.
But you do have their presentation, I believe, Grace, so you have that. We'll schedule another time.
Thank you. Next, moving into finance matters, item number one, payment of the February 18, 2026 accounts payable current claims report in the amount of $1,055,551.72. Could I get a motion, please?
So moved.
Moved by Lamore. Is there support?
Second.
Supported by Heinzerling. Now I'll turn it over to Sue.
Good evening. On page number one, vendor number 40572, DeWolf and Associates, is training for a dispatch and sheriff employee. On page number two, vendor number 60205, Fiddler Technologies, it's an annual fee for the Register of Deeds software. Vendor number 80904, House Arrest Services, it's the December indigent tether services provided through various courts. On page number four, vendor number 190935, Schoolcraft College. It's a cadet academy for 6 recruits. Page number five, vendor number 510855, Title Check LLC, certified mail fees for the tax foreclosure notices. And on page number seven, vendor number 903107, Lenawee County Drain Commissioner, is reimbursement of county portion of maintenance on a shared drain, and that's the end of my list.
Other questions?
Just have one question, please. We're on the first page there, this affordable interior systems. I know it's probably one of the big projects, but
I believe
That's
that was
all in order, that
furniture for the
88,000?
Stoner Kemmerling project.
I'm just curious so it's just an order. It's affordable interior systems, 88,000. Is that on one of the, with Jamie, or it's not Jamie?
It's the Stoner Kemmerling project. It's the furniture replacement for Stoner Kemmerling project.
So we, thank you,
Yes, it is another big project.
thank you.
Sure.
Other questions? I have a question on page 6, vendor code number 750521. What period of time is that amount for?
That I do not know, but it is 68 individual invoices. So I would imagine that's more than a month. I don't know that without looking.
Okay, because when I read this forensic audit, part of it said the county noted, as the review took place, changes were made by the county office to practices and procedures related to assignment procedures, caseload distribution, billing software,
Mr.
and
Chair,
tracking monthly.
Can I interrupt you a second? I agree with all of your may I quickly? I'm familiar with this matter, and there was an internal issue with this individual vendor's office where they needed to get new staffing, and so those 68 invoices represent a backlog where things were submitted from prior things, and I'm totally on the same page where, we're supposed to be getting these updates, so it just doesn't come to us blindly. But I get these, and I do my due diligence, and I speak out. So this represents a couple months when that individual attorney was short-staffed to get their invoices in.
I fully accept that, but it would just help us because it was stated that there's going to be tracking monthly. And so if there was tracking monthly, there could be a little side note with the claims to say, listen, there's 68 different entries, and this is because there was a snafu with the billing system, and so it covers not just 1 month, but it covers 3 months. Makes it a lot easier to vote on the entire claim package when we know this kind of thing. Does that make sense?
Yes, I think that information would be better to come through the MIDC office, though. So do you want to have an addendum to this report?
Well, because it said the county noted, so if that's the MIDC office, then why aren't they doing that for us? That'd be the question.
I can't answer for them.
Okay. All right. Any other questions? Thank you. Roll call, please.
Commissioner Lamore?
Yes.
Commissioner Wenzel?
Yes.
Commissioner Swartout?
Yes.
Commissioner Moore?
Yes.
Commissioner Levens?
No.
Commissioner Hoffman?
Yes.
Commissioner Asper?
Yes.
Commissioner Heinzerling?
Yes.
Motion carries.
Thank you.
Thank you.
Sue, thanks, Sue. Look at this.
Yeah, I know, it's still there.
Next up is item number 2, letter dated February 9, 2026, from Mr. Jesse Stanford, Monroe County Treasurer, submitting the cash and investment report for the quarter ended December 31, 2025. Could we get a motion, please?
Make the motion.
I'll second that.
Moved by Heinzling, supported by Huffman. I'll turn it over to Jesse. Thank you.
I'll make this real quick. It's been a long night. Basically, over quarter four, we saw the Federal Reserve cut rates twice, once in October and once in December. So that's the big news of quarter four for our investments. It's made it harder for me to get the same investment because the rates are going down to that degree. And I'll answer any questions, or attempt to anyway.
Any questions for Jesse? Thank you. Hearing none, roll call, please.
Commissioner Wenzel?
Yes.
Commissioner Swartout?
Yes.
Commissioner Moore?
Yes.
Commissioner Levens?
Yes.
Commissioner Hoffman?
Yes.
Commissioner Asper?
Yes.
Commissioner Heinzerling?
Yes.
Commissioner Lamore?
Yes.
Motion carries.
Thank you.
Thank you. Next, under consent agenda, approval of non-claims. Item A, check register dated February 6, 2026, in the amount of $1,453,015.44. Item B, check register dated February 13, 2026, in the amount of $425,137.67. Could I get a motion, please? Moved by Swartout.
Second.
Supported by Heinzerling. Any questions on this motion? Seeing none, roll call, please.
Commissioner Swartout?
Yes.
Commissioner Moore?
Yes.
Commissioner Levens?
Yes.
Commissioner Hoffman?
Yes.
Commissioner Asper?
Yes.
Commissioner Heinzerling?
Yes.
Commissioner Lamore?
Yes.
Commissioner Wenzel?
Yes.
Motion carries.
Next, under communications, letter dated February 6, 2026, from Mr. Michael Predmore, Chief Deputy, requesting approval to apply for the fiscal year 2026 Marine Safety Grant to the Michigan Department of Natural Resources in the amount of $59,804. The potential local match is included in the 2026 adopted budget. Could I get a
Make the
motion?
motion.
Second.
Moved by Heinzerling, supported by Lamore. Any questions on this motion? Seeing none, roll call, please.
Commissioner Moore?
Yes.
Commissioner Levens?
Yes.
Commissioner Hoffman,
Yes.
Commissioner Asper,
Yes.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout.
Yes.
Motion carries.
Item number 2, letter dated February 9th, 2026, from Ms. Jamie Dean, Health Director, requesting approval to accept a public health capacity buildings mini grant in the amount of $10,000 with no matching funds required. Could I get a
I'll
motion?
make the motion.
I'll
Second.
second that.
Moved by Levin, supported by Huffman. Any questions on this motion? Hearing none, roll call, please.
Commissioner Levens,
Yes.
Commissioner Hoffman,
Yes.
Commissioner Asper,
Yes.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout,
Yes.
Commissioner Moore.
Yes.
Motion carries.
And item number 3, letter dated February 17, 2026, from Mr. Jason Berry, Community Planning and Engagement Director, requesting approval to apply for the 2026 Michigan Public Safety Critical Incident Mapping Competitive Grant for $23,785.60 with no local matching funds required. Could I get a motion?
Second.
Moved by Swartout, supported by Heinzerling. Are there questions on this motion?
What is a safety critical incident mapping competitive grant, Mr. Berry?
Good evening, everyone. This is a grant that we hope to apply for to help update our current mapping system. Currently, we have maps that if there was a critical incident that happened, first responders would use them to best respond. But this grant will help us contract with the critical response group to provide all that in an electronic platform so that all first responders arrive to a scene and can log into the system and be able to communicate with the commander and know every inch inside of each of these buildings further to help them with their response.
And so, Mr. Berry, the example you gave us is this postcard that shows a demo of a high school. For example, this is the product that they would eventually provide to first responders.
It's an overview, and we have Mr. Zach Query here with us with the CRG group or with the CRG organization who could answer that. But it's an overview because this program will have aerial views. We understand then it'll also be able to zoom in and comb through all sorts of exits and entrances. And just so you know that this group has already worked with many of our local schools, including Monroe, Whiteford, Ida Townships, their schools as well, to be able to offer this service for first responders. So, so we have 9 in front of you to consider. If this was approved by the commissioners tonight, we could have 2 more grants, eligible for 3 total, that we could look into other buildings down the road. CRG recommended that we begin this project with these 9. Sheriff, I spoke with the sheriff on this. He fully supports this. He thinks this would be great for our first responders to have access to. Got Mr. Query here. If he could answer any more of the more specific questions of what this looks like, pulling it up on a platform, and so forth. So.
I have one question. You think this is going to help cure when I know that we got several streets in the county where first responders, and I've been in the same situation way back when I was on the fire department, where you get there and the address is on another street, but it's the same street, but it's maybe 3 miles or 5 miles or 10 miles, 20 miles from where you're at, and it falls into your zone with
These
your
are
number
only our
called,
buildings, I think.
and you're at the wrong place. This is going to correct some of that, because I know that's been crucial.
Yeah, I think that's a separate issue, which my departments are meeting with 911 and Ms. Donna Cootie to talk about that next week,
Yes, I know
actually.
we're trying to get that solved out there, yes.
Yeah, that's going to deal more with the overlap and the addresses that come across as confusing to first responders. This is dealing with the actual building, like the health department, the courthouse, and so forth. So, if, for example, in this building, if something were to happen, first responders arrive, they log into the system, they can tell you where the exit is, everywhere that they would need to know, with who's ever in command can then make decisions. So, it's a little bit of a.
So they'll have to tour all the buildings then, correct?
Yeah, they're going to be using the technologies, someone asked why wouldn't the county do this? Well, we don't have these technologies to do that. And that's
I can see where it's very good, because when you're on a call and the room's full of smoke, or you got somebody down somewhere and you don't even know the first thing about the building, and a lot of lives can be saved and rescued. No, I agree. It's probably well needed. Probably well needed.
Commissioner Asper?
So does this include like hardware for this, or how do they, when you say they pull it up, what are they pulling it up on?
That's a great question, ma'am. So my name is Zach Query. I'm the director for Michigan at Critical Response Group. My background, very briefly, I spent a little bit over a decade in Army Special Operations, where I was introduced to this mapping technique overseas. Ultimately, we are not there's no additional technology required. How this works is we take the old floor plans that are typically out of date. They're never accurate. They're never accessible to the responders that need them. We come on site to these locations. We walk the structures. We fix the maps. We make them accurate. And we gather the key data that's useful to responders inside the building. So, fire alarm control panels, fire hydrants, AEDs, the things that matter to the first responders, and they respond from anything from a medical emergency to the worst case scenario of an active threat. When we look at these large-scale active threat incidents that tragically occur across our country, it's never one agency that shows up to these things. You have municipal, county, state, surrounding counties pushing resources, and everybody has a different technology platform. Everybody has a different software. So the way we approach this is we manipulate this mapping data to put it into the systems that your first responders use every single day. So if there's an emergency at the courthouse, 911 pulls it up in the system that they have and use for every single call. The municipal police department has it on the laptops in their vehicles, as well as the fire department may have a mobile application that they use. So we simply take our team, we go meet all those agencies, we get these maps in their systems, so everybody speaks the same language when they approach on a scene and converge when they've never worked together before. So, Michigan has been a fantastic state. They have funded and actually made legislation around school mapping standards. We had the great fortune of winning about 90% of that business in the state of Michigan. They then released more funding to do higher education, where we came in and done, all the community colleges, a lot of the universities in the state, and now they've expanded it to critical infrastructure for communities as well. So your government buildings, hospitals, things of that nature, which is what we're kind of talking about today. So, ma'am, I hope that answers your question.
Thank you.
Thank you.
Yes.
Zach, I want to thank you for your service.
Thank you, sir.
And so, from a ROTC S2 wannabe dropout, I have to give you a hard time. Most people cross over to Delta. You crossed over to Nerd.
Yeah, that's fair. That's
All right,
fair.
fair enough. Thank you for your service.
Yeah, thank you, sir.
All right. Roll call, please.
Commissioner Hoffman,
Yes, yes.
Commissioner Asper,
Yes.
Commissioner Heinzerling,
Yes.
Commissioner Lamore,
Yes.
Commissioner Wenzel,
Yes.
Commissioner Swartout,
Yes.
Commissioner Moore,
Yes.
Commissioner Levens.
Yes.
Motion carries.
Thank you. We have no public hearings. Is there any old business? Any new business? We now enter the second segment of public comment. Are there citizens who wish to address the board?
What the heck, I've waited this long. Gail Kane, District 8. The first thing I wanted to address is this big money that was spent in the legal realm of upstairs there on third floor or fourth, wherever. I heard the word staff. That tells me it's an employee. So you're taking care of it legally, but what are the consequences to the staff that was referred to that wasn't sharing this information with you? I would think that is something within your control. As to the other, there was another question asked about does MTIS, I might have my letters wrong, and the person said they didn't know how they could control that. I got a problem with that, people. I got a problem with that. If you're going to get up here and some group within whatever the money situation is has been told and has promised a certain product, somebody better have an answer as to why it's not being done that way and not just sloughed under the rugs. Because frankly, that's kind of what I kind of got out of tonight's meeting. I applaud all of you. I don't want your job. I'm not going to run your job, but I could very well recall. You took your legal advice as best you could, and they've done a great job. I took offense because I'm one of those ignorant idiots out here in the public that doesn't know the law, or so I've been informed. The oath of office that you take says you're going to follow the Constitution of the state. And so I was very pleased to hear the one commissioner admit that as a chiropractor, she wasn't an attorney, because she certainly made herself sound like it. And I kind of got the feeling that it has to be her way or no way at all. And when she's nodding, when someone else is talking, and we've got our radical side. And so when she's nodding and the other person is talking out of the three who don't seem to get along with the rest of you in the sandbox, it's obvious that they do convene and make decisions before the meetings when it's been implied on the reverse. I'm sorry, but I see the three people that are sitting to the radical right as an obstruction in the role of their oath of office within this county, and it's what's causing the backlog to happen. The courts were not even clear. So I didn't appreciate the legal having their fingers pointed. He's done his job as best as he can. I wouldn't want his job either. And he's willing to step up to the plate and say he's done what he feels is the right thing to do. If he isn't going to be willing to take that oath and that commitment, then it's malpractice. And he certainly doesn't want to be nailed with that. So I'm sorry, people, but I got more confused after tonight. Maybe a timeline could be put together as to what happened and what didn't happen. And better yet, I would like to put out forth a settlement. I would like to see Mr. Brandt come to this table, and I would like to see him wave his white flag, because that's what you do when you quit, and say, I'm dropping my case against the county, and I am willing to vacate my seat. Then I want Mr. Banicki to come up here and vacate his seat so that District 2 can move forward on having an election. That would close the doors on this whole entire thing. It would save the money, and it certainly would put some sort of ethical and moral faction to this whole thing. You guys have had your hands tied, and you can't point fingers there. But if you're not going to come together as a group and you're going to stand in obstruction of what your legal counsel is telling, and you're going to make the claim that you know more than your attorney when you're not an attorney, it's a problem. And the oath of office says you're going to follow the state constitution, and the attorney stood right here and said he was following state law. So I'm sorry, I'm stupid. I am ignorant. I don't know the law. So I guess you're going to just have to go along with my shooting from the hips. But, continue doing what you got to do, boys. You just got to keep plucking through it. Thanks.
Good evening. Thank you for following through with this process. I just want to thank you for the transparency. I think the public attending today and watching online has really appreciated that. We can follow along, we can learn, we can understand, and it just is very gratifying and helpful for it to be in the daylight. So thank you.
Well, earlier I said something about you have a dog in the fight. And it sounds like you've decided to turn your dog loose. That's okay. I was pleased tonight that this issue with respect to District 2 was done in public. The lawyer stood up here and gave you alternatives. He explained what his view was of the Court of Appeals decision. And each and every one of you had an opportunity to respond to the public about your opinion. Some of you did, some of you didn't. We would have never heard that in a closed session. So sometimes closed sessions are not really in the best interest of the group. Sometimes clearing the air, even if you don't agree, clearing the air and watching the citizens or have the citizens watch what you're doing is more important than being in that back room and say the same thing, but we never hear it. Now, I have to tell you, I've been involved in a lot of closed sessions. Often I would say, no, we shouldn't do that, because whatever you say in closed session, you should be able to say right here. But there are times when it's absolutely necessary to go there. But I think tonight you did the right thing. Back to the lawyers. I just saw Sue put stuff up on the board here, and what appeared to be several lawyers put in 40 invoices. Now, none of you can take the time to go through 40 invoices and decide whether or not they're valid and did they do the work. You don't have time. So I don't have an answer for you, and I know Henry was adamant in his issue with respect to whether or not you would pay these people or not pay them. I'm not going to get involved. I don't have a dog in that. But I see just on the board, the number of invoices would appear to be from lawyers, and you don't have time to look at all that. So I don't know what your system is in place to check on that. I don't know. I know when I sat there, we never looked at them. We kind of just paid them. But if you're going to start moaning and complaining about lawyers' bills, then you have to put a system in place to analyze them. You have to have a system in place for somebody to look over them. And that's not a fun job. I mean, I see used to see the bills from the law firm. They do a good job in telling you what they did, who they said, who they spent time with. They did a great job. Others would just simply say worked, and send an invoice. I don't know how you can fix it. I just don't know. But every lawyer keeps a calendar. Every lawyer keeps a calendar. And maybe that's what you require to be delivered with the invoice. I don't know. That's a lot of work, a lot of paperwork. They'll charge you for that too. Thank you.
Any other citizens that wish to address the board? Seeing none, we have no announcements. We'll move into members' time. Commissioner Asper.
I would just like to assure Ms. King that we do have an ethics policy. When the board did not make one after we had this committee and everything put together, and we still didn't get one, I put one together and we passed it, just so you know that we do have one. And I was kind of, to be called a radical is kind of nice. When you're 72, that's not too bad. But anyway, I do have critical thinking skills, and I just simply want us to follow the law, and I just simply want us to make sure that our motives are pure, and I just want to say the truth and then let it go free because it can defend itself.
Commissioner Moore.
Well, congratulations, everyone. You survived. We didn't go into closed session, and the world didn't end. And much like the former chairman said, and some of the constituents out here, I agreed with some of their points at public comment tonight. Although permissible, it's not always needed to go into closed session for the sake of transparency and for the sake of understanding and making sure that the public understands what's going on. I'm glad that we ended up not going into closed session for those two items. I think both of those things needed to be stated publicly. And I would hope that the majority of this board takes heed of that and thinks twice maybe about going into closed session about every controversial or sensitive topic. Just because it's controversial or sensitive doesn't necessarily mean it can't be discussed openly and calmly like it was here tonight. With that being said, I am disappointed that my fellow commissioner wouldn't allow me to vote on the two issues separately. I've supported it. I've supported Commissioner Levens for over a year. Well, I think it's about a year and a half almost, maybe a year, on this issue of making sure there's no fraud within that department. It's no secret that he vehemently wants to have a public defender's office, and I disagree with him. This was a Trojan horse way to be able to, on the back of fraud, to then say, well, let's also look at this issue. And it's just disappointing because it's a dirty political trick when you put two separate issues on the same vote. You force your fellow commissioner to either vote one way or another. So at a later date, you can say, well, see, he voted for that, or see, he voted against that. We see it done in Washington all the time. We see it done in Lansing. I don't think it should be done here at the Board of Commissioners. I would hope that in the future, if a commissioner wants to separate a vote and say, look, I agree on this issue, I disagree on that issue, can we separate it? We should be able to say, yeah, let's take a second vote. And I'm sure they had the votes for it. It would have passed anyway. But I would hope that I would be allotted that grace to be able to vote my conscience on each different separate subject that comes up. And then thirdly, I did have something personal that I wanted to publicly say to Dave Hoffman. I'm going to hold that. Well, I'll talk to him privately. I'll pass.
Commissioner Swartout?
I'll pass.
Commissioner Heinzerling?
I'll pass as well.
Commissioner Levens? Commissioner Hoffman?
I'm going to pass.
Commissioner Lamore?
I really do think that this report from Plant Moran was very helpful. And if it was helpful to me, then why wouldn't it be helpful to those other bodies that make decisions, such as whether we should have a public defender's office or not? So why would we avoid sending that to them? Isn't that a misrepresentation of the truth as well? My opinion, this is definitely truth, and it's definitely something that needs to be followed, and it's definitely something that should be viewed by all parties involved so that we can make great decisions here and have the right people in place to help these people do their job. And up to this time, we're seeing some people in here that weren't doing their job or weren't appropriately doing their job. This is going to guide us in the future, in my opinion. I'll pass on the rest.
Mr. Bosanic, anything for the board? Mr. Graham? I'll just make a few comments. I'm very thankful that, first of all, I'm grateful for the work of Phil Goldsmith on this entire legal challenge that we've been faced with over the last year and a half. I think he's done outstanding work, and I'm thankful that we're going to see it through to the end, and that we had the votes to allow him to do his work. And if it ends up in the Attorney General's office or ends up back in the Circuit Court or eventually the Appellate Court, that we'll get a final decision on whether the seat was vacated or not. Just a couple of responses to some comments that Commissioner Asper made. She made mention of the fact that in the 2024 election, former Commissioner Brandt received 90% of the vote. But what she failed to mention was that he pled guilty in March, didn't let anybody know until the sentencing in September, well past the date where anybody could file if they want to run against him. And I will say this for Mr. Brandt, he was a very successful county commissioner. He was in office for several years, and so the idea of somebody running against him, especially in his own party, were slim to none. And really the same with the Democratic side, based on the demographics of District 2. And so to say that he had 90% of the vote is a little bit misleading because he was the only name on the ballot. And although it was pointed out to me tonight that him not informing the county board that he pled guilty in March and waiting until his sentencing in September wasn't anything illegal or caused us problems if he remained on the board in the interim and voted in certain ways, we're safe with that. But what it does raise is ethical concerns about, did he have an obligation to report to his colleagues on this board that he had pled guilty in March? Did he have a even greater obligation to allow his constituents in District 2 know that he had pled guilty and was awaiting sentencing. Instead, didn't tell anybody, got on the ballot as the only candidate and won with 90% of the vote. As far as my former colleague that sat in this seat appointing somebody, it wasn't immediately after the sentencing that former Commissioner Brandt resigned. And so by the time the resignation was in place, it was a very limited amount of time where an appointment would have been made. It was former Chairman Richardville's decision not to do that and let the election play out. And I can be corrected if I'm wrong on this, but I'm quite sure that after Mr. Brandt won that election, I did not, as the new chairman coming in January, have the legal authority to appoint a replacement for Mr. Brandt while we waited what was going to happen with his sentence or waited for him to get out of federal prison. I didn't have that legal authority to appoint somebody. We only had a few options which were researched by Mr. Goldsmith. And so what I'm very grateful for tonight is we are going to be able to see this through finally. So